Hello friends, very warm welcome to my channel Business Laws. Till now friends, I have covered up to chapter number 5. Today I am going to take up chapter number 6, which is legality of object or consideration. So important questions friends which are asked from this chapter. There are 2 questions which I have written here. First question is explain the doctrine of public policy, discuss the agreements opposed to public policy. And second question is write notes on the following. First is maintenance and champerty. Second is agreement with object or consideration unlawful in part. And next, effects of illegal agreements with suitable examples. For all the questions, I will answer one by one. First one is doctrine of public policy. So friends, when this question is asked, you must define what do you understand by the term doctrine of public policy. So the definition of the term public policy as such, it has not been provided under section 23 of the ICA 1872. Lord Trudeau has defined public policy in one of the case laws. Public policy is that principle of law which holds that no subject can lawfully do that which has a tendency to be injurious to the public or against the public good, which may be termed the policy of the law or public policy in relation to the law. So public policy is not capable of exact definition. It has been described as untrustworthy guide or unruly horse, etc., etc. And Supreme Court has held in one of the cases that heads of public policy can be evolved in the light of fundamental rights and directive principles of the Constitution of India. So friends, the heads of public policy, they are not closed. So it is for the courts that if they find that some agreement is against the interest of the public, then that will be put under the category of agreements opposed to public policy. Now having discussed the term public policy, and now friends, I would like to take up which are those agreements which have been regarded as opposed to public policy. Now let me tell you friends, what is the meaning of agreements opposed to public policy? An agreement is said to be against the public policy or opposed to public policy when it is injurious to public interest. The following agreements have been held to be opposed to public policy and therefore they have been regarded as void. The very first point is trading with an alien enemy. Alien friend can contract, but alien enemy cannot. You all know, friends. It is so because these agreements tend to add to the economy of enemy country. They will benefit the economy of enemy country and not our own country. Such agreements are therefore illegal unless made with the permission of the central government. So whenever there is outbreak of war between the two countries, and then the contract has to be suspended, which can be revived once the war is over. The second point is agreements interfering with the course of justice. Any agreement, the object of which is to interfere in any manner with the course of justice is void. So friends, if an agreement is to refer present or future dispute to arbitration, it is a valid agreement. Friends, broadly speaking, there are 2 ways of settling disputes. One is a formal, other is informal. When any present dispute, existing dispute or future dispute that is referred to the arbitration, this is a valid agreement. Parties may decide they would like to adopt which course. So the examples of agreements interfering with the course of justice: an agreement to bribe witnesses to give false evidence. The witnesses know what is the truth, but they are given the bribe just to shut their mouth or to give the false evidence in the court of law. And second is an example to give money to the judge or officer of the court for securing judgment in favor of litigant in a suit. Person has committed murder. He meets a judge and he bribes him and he says, please do not take the decision in my favor. So such agreement also interferes with the course of justice. Therefore, it is void. Now, third point is agreements for stifling criminal prosecution. Any agreement which is not to prosecute the offender or to withdraw pending prosecution is known as agreement to stifle prosecution and is therefore void. Anyone who has committed crime must have to bear the punishment for that. It is said, you shall not make a trade of a felony, that is major crime. If you are aware that a crime has been committed, you shall not convert that crime into a source of profit or benefit to yourself. An agreement compromising a non-compoundable offense is void. Offense may be compoundable or non-compoundable, but non-compoundable offense cannot be compromised. And if it is trying to be compromised, then in that case it will be void. But there are certain offenses under Indian Criminal Procedure Code which are compoundable. Assault is a very good example of this. And now, friends, after this, I will take over more points. The case law is before you. This is self-explanatory. And if you find any problem, you can always write in the chat box. Here in this particular case law, there was a deficiency which was made up by the party, but some delay was made by the party in making up the deficiency. But before this, the suit was, when this was made, then the suit was withdrawn by the bank. So it was held in the court of law and agreement to make up the deficiency was valid. Now, next point is very important point, friends, which is maintenance and champerty. Maintenance. What is maintenance and what is champerty? I would like to explain with the help of example. Maintenance is an agreement whereby a person assisting another financially or otherwise in litigation in which the third party has no legal interest of his own. Friends, this last line is very important. In which the third party has no legal interest of his own. Now, what is champerty? Champerty is an agreement whereby a person agrees to assist another in litigation in return for his share in the proceeds of the action. Why is he helping others? Because he has his own interest. He says that, advocate helps the creditor in filing a suit against the debtor. And he says, whatever money you recover, you pay me 30-40% of that. So this transaction is champertous because a person has his own interest. If I twist the example, I say that the advocate has helped the creditor and in filing a suit against the debtor, and he has no interest of his own. Whatever money creditor is able to recover from the debtor. Now, advocate is not going to charge anything from the creditor. So this will be known as in the form of maintenance. Thus, friends, in both the cases, financial or professional assistance is provided to help another person in litigation. But in the case of champerty, the party helping the litigation also shares the proceeds of the litigation in addition to interest on money advanced or fees for the professional services. So now the question arises, what is the status of these two in English law as well as in Indian law? Under the English law, both these agreements are illegal and void. So friends, you all understand what is illegal and what is void, because illegal and void cannot be used interchangeably. Under the Indian law, agreement to share the proceeds of the litigation are not regarded as opposed to public policy unless they are exorbitant and they are unconscionable. If the amount is exorbitant, it is unreasonable amount. Say the lawyer in the example which I have taken here. The lawyer says that you pay me 70% of this. Then 70% is law and share. It is unreasonable amount. So here, friends, this will not be valid. So friends, I have explained with the help of example, the term of maintenance and champerty. Coming to the next point, which is trafficking in public offices and titles. What is the meaning of the term trafficking? It means sale or purchase. Agreement for the sale or transfer of public offices or procurement of public title like Bharat Ratna, Paramveer Chakra, or any post, public post, manager or CEO. Okay, so that is transferred just for consideration, and this is against the interest of the public. Bharat Ratna, person cannot get just by paying money. So such agreements, if enforced, would encourage inefficiency and corruption in public life. So friends, one person is managing the bank and another person says that, okay, he's looking for the job and he says, I'll pay you 10 lakhs and you transfer this post in my favor. It is not possible. Any person who can afford to pay money will occupy the highest post. So here agreement is not valid, it is void. Even, students, friends, there wherever there is entrance test, the student qualifies the entrance test and then the person secures the admission. If other person says, okay, you pay me 10,000 rupees, I'll get you, I'll provide you the seat for your son in the college. It is not possible. It is not possible, friends. The person may get the money and still, the seat is not given to his son in the college. These agreements are not valid, they are void. Even the money paid cannot be recovered through the court of law. So wherever there are no paid seats, people should always aware, from the touts. Now, agreement creating an interest opposed to duty. Any agreement which tends to create or conflict between interest and duty is illegal, and it is always regarded as void on the ground of public policy. Friends, agent interest is to earn secret amount of profits, but his duty is he should always act in the best interest of his principal. Say for example, friends, P gives directions to his agent A to buy a certain flat for him in Dwarka. And agent tells the principal that no flat is available for sale in that area, but buys the flat for himself. So smart. And if the same is discovered subsequently by P, he may compel A to sell it to him, to principal, at the price which was paid by A person. So any agreement which creates an interest opposed to duty is not valid, it is void. Then next is agreements unduly restraining personal liberty. Everybody has the right to live with freedom. Nobody can, put restrictions on his personal liberty. And if they are imposed, then those restrictions, that agreement will not be valid, it will be void. A borrowed money from B. A was a borrower, B was creditor. And they agreed that he would not, without the written consent of B, borrow money, part with his property, change his residence, or leave his job. If debtor has borrowed money from creditor, no, it is enough on his part. He pays the money along with interest. No, creditor cannot put restriction upon him that you are not allowed to change your residence or you are not allowed to change your job. So it means unduly the freedom of debtor is being restrained. So this agreement will not be valid, it will be void. Then agreements interfering with parental status. Any agreement which interferes with the parental status, because father and in the absence of father, mother is the legal guardian of his or her minor child. This right cannot be bartered away by any agreement. Any such agreement which contemplates an absolute transfer of the rights of parents over their children is void as being against the interest of the public. The case law is here, which is Ram versus Bankumal. For monetary consideration, A agrees to place his daughter at the disposal of B, to be married according to the wishes of B. The decision given in the court was that this agreement was void and illegal, as it would interfere with A's parental duties to select a husband in the best interest of his daughter. And now, friends, coming to the last point, which is marriage brokerage agreements. Any agreement to procure the marriage of a person for monetary consideration is called marriage brokerage agreement. Such agreements are illegal and void as being opposed to public policy. Similarly, an agreement to give money or property, that is dowry, to the parents of a bride or bridegroom for their consent to the contract of marriage is also illegal and not enforceable under the Dowry Prohibition Act. So friends, here say father of the bride promises to give cash worth rupees 2 lakh and ornaments worth rupees 4 lakh to B, father of the bridegroom, on the marriage of his daughter. The agreement is void and cannot be enforced. Now friends, I'll take up various cases and tell you the rule. In case A has given money and ornaments at the time of marriage, he cannot recover from B. Once the money is given, ornaments are given, then they cannot be recovered through the court of law. In case A has not given the stated amount and ornaments, then same cannot be recovered from him by filing a suit. However, if A has given amount and ornaments and same or their value can be recovered, if marriage is not performed, if marriage is not solemnized, somehow after engagement but before marriage the relationship is broken, then friends, that amount which is given and the ornaments can be recovered by filing a suit. Now the last point here is, friends, miscellaneous cases. The following agreements are also void as being opposed to public policy. Any additional point apart from the 9 points which I have explained, if you find, you can put under the category of miscellaneous cases. 5 points I would like to discuss here. First one is agreements tending to create monopolies. Any agreement whose main motive is to create monopoly, it is not valid, it is void. Agreements to defraud revenue authorities, income tax authorities, or sale tax authorities. People try to evade tax. Then their main motive is to cheat the revenue authorities. This agreement is not valid, it is void. Agreement whereby persons are induced to give evidences in the civil court for a monetary consideration. Say, for example, accident has taken place and there is eyewitness to that. And then, the other person, the wrongdoer, he pays him money. He says, you change your statement in the court of law. Give wrong evidence, false evidence. Okay, so here, this is also against the interest of the public. Agreements to influence election to public offices. Elections do take place in the country for various posts. So here, friends, sometimes, the public is lured by the, contestant. Cash is distributed or kinds are, the people are pleased by way of kinds. Then also, friends, and people, they enjoy these things and they will cast the vote in favor of that party. This agreement is also not valid, it is void. Vote cannot be purchased. It is the people's democratic right in which party's favor they would like to cast their vote. Then agreements not to bid against each other, not to bid against each other. What is their main motive? To minimize the price. Even this agreement is not valid. A and B decide that they are going to participate in the bid and both will not bid against each other. So what is their main motive? Main motive is to reduce the price or to keep the price minimum. Even this agreement is not valid, it is void. So friends, I have explained all the points now. So if question is asked, what do you mean by the term public policy, and which are the agreements which have been regarded as opposed to public policy, then all these points you will have to write along with the explanation or case laws which I have explained. I hope you must have understood the points, and if you have any doubt, do write in the comment section. And now I'll take up the second question. Short notes. Object or consideration is unlawful in part. There are certain cases where we do find the objective or consideration is unlawful in part. That is, partially it is legal and partially it is illegal. And these provisions have been laid down under sections 24, 57 and 58 of the Act, ICA 1872. The 3 points. First point is agreements void if considerations and objects are unlawful in part. Where an agreement contains several distinct promises to do certain acts which are legal and other acts which are illegal, and the legal act is not separable from the illegal one, and consideration is the single sum of money, the whole agreement is illegal and void. Say for example, A is appointed in the factory and is given the task by the factory manager that you will have to manufacture legal parts, original parts, and for this you will be paid salary of 20,000 rupees. And you will also have to manufacture duplicate parts. For this you will be given the salary of 30,000 rupees. No, here he says you will get 50,000 rupees. That is, consideration is the single sum of money. The employee doesn't know how much is for the manufacturing of legal part and how much is for illegal part. 50,000 is a salary. Then in that case, friends, so we cannot separate the legal from illegal. The whole agreement will be illegal and void. Now coming to the second point, which is reciprocal promise to do certain things legal and other things illegal. Where there is a reciprocal promise to do certain things legal and other things illegal, and legal act is separable from the illegal act. Consideration is not the single sum of money, but consideration is separate for legal and separate for illegal. The same example I will take and explain. If 20,000 is given to the employee for manufacturing of legal part and 30,000 for manufacturing of illegal part, then for legal part is a contract and for illegal part is void and illegal agreement. So friends, I hope you are clear about all these points which I have explained. Then alternate promise, one branch of being illegal. In the case of alternate promise, one branch is legal, other branch is illegal, and it is a legal branch only which can be enforced. A and B agree that A shall pay B 1,000 rupees, for which B shall afterwards deliver to A either rice or smuggled afim. If he, gives him rice, then he can recover the money. But if he gives smuggled afim, fixed quantity of smuggled afim, then money cannot be recovered by the seller through the court of law. This is all about those cases where objective or consideration is illegal in part. That is, partially it is legal and partially it is illegal. And now friends, coming to the third question, which is effects of illegal agreements. What is illegal agreement? Already friends, I have covered this under the very first chapter, under the heading kinds of contract or classification of contract. But what are their consequences? What are their effects? Now these effects I am going to take up today. 4 points are there. First is agreement to section. According to section 23 of the Act, all the agreements entered into regarding this where consideration is illegal or objective is illegal are void ab initio. Murder, assassination, plotting a bomb. Okay, all these agreements are illegal. The general rule of law is that no action is allowed on an illegal agreement. Second is collateral transactions. Collateral transactions are also tainted with illegality, and therefore they are not enforceable provided the parties to the collateral transaction were aware of the illegal purpose of the main transaction. Very good example of this is wagering agreement. In case of wagering agreement, collateral transaction is always regarded as valid. Third is the principle of restitution. Principle of restitution is never applicable in case of illegal agreement. When a person knows from the very beginning agreement is void and illegal, he should not have paid the money. Once he has paid the money, then the money cannot be recovered through the court of law. Fourth is where the parties are in pari delicto, that is equally guilty. This is a law term, which means both the parties are equally guilty. The defendant is always in a better position than that of plaintiff. So friends, examples I will take up. First is very clear to you. So a smuggled laptop, this is illegal. Second one is A agrees to pay 50,000 rupees to B if B kidnaps C. A borrows money from D in order to pay to B. D cannot recover the money lent if D was aware of the purpose, because lending of money was a collateral transaction to an illegal agreement. Person should be aware why is the money, for which purpose the money is being lent. But if he is not aware of the purpose, then he can recover even if he had used the money for illegal purpose. So friends, after this, the last point, third point is regarding regarding one of the impacts of illegal agreement. The fourth is A agrees to pay rupees 50,000 to B if B shoots C person. If B shoots C, he cannot recover the money from A because purpose is illegal. But if A has already paid the money and B does not fulfill his obligation, then A cannot recover this money from B because the rule of restitution is not applicable in case of illegal agreement. So position of defendant B has got the benefit here. He has not committed committed the shoot of C person, but he has got the benefit. His position is always better than that of plaintiff, that is A person. So friends, this is all from my side. I hope you will like the content. You must have understood all the points which I've covered. And still, if you have any doubt, do write in the comment section. So do like my videos, do subscribe to my channel, do press on the bell icon to get notifications of my subsequent videos. Keep smiling always and stay blessed always. Okay friends, bye-bye.